Hi, welcome to our supervisor training for British Columbia's Public Interest Disclosure Act. If you're here, that means you're a supervisor in an organization that is or is about to come under the jurisdiction of the Act. My name is Rachel Warren. I am the manager of the Ombudsperson's Consultation and Training team, and I'm joined today by Lindsay Hunt, our office's learning specialist, who will be presenting in just a few minutes. So I'd like to start by just saying that both Lindsay and I are delivering this webinar from the unceded territory of the Lekwungen people, the Esquimalt and Songhees First Nations. And our work also extends across the homelands of Indigenous peoples in what is now known as British Columbia. And we humbly acknowledge the current and traditional stewards of these lands. And we'd also like to invite you to reflect on the land that you're working and living on and refer here to the link provided on the screen to find out more about the history, language, and culture of the First Nations in your area. Before we begin, we want to clarify who this webinar is intended for. The information we'll be presenting today is geared towards supervisors of employees who work in organizations who are either under the jurisdiction of the Public Interest Disclosure Act, or PIDA, or are about to be covered under the Act as it rolls out to the broader public sector in April 2022 and beyond. So if you're someone who supervises employees and your organizational structure is such that the employees report to you, then you have specific responsibilities under PIDA. This webinar will provide a rundown of those responsibilities that you have as a supervisor under PIDA, and we have lots more resources for you on our website. So let's get started. So imagine you as a supervisor have an employee come to you about a concern they have. So this could be something that happened to them directly, something that they witnessed, or something that they heard about. But it's something they feel is wrong and they want to tell you about it. Well, you have a number of tools in your toolbox to help this employee out. You may have different processes and procedures under human resources, ethics and standards of conduct, or workplace safety to address this employee's concern. So think for a moment about all those tools that you already have. Maybe you've used some in your work already. They might be different tools depending on your workplace or sector. Well, the Public Interest Disclosure Act, or PIDA, what we're covering here today, is another tool for your toolbox if you work for an organization that is covered by the Act. And what's important to know, what we're going to be talking about today is, what is this tool? What is PIDA all about? What are my responsibilities as a supervisor under PIDA? And what are some of the do's and don'ts, some tips to help you to use this tool? So we'll be introducing throughout the webinar some what-if scenarios to hopefully show you how to actually apply and enact your responsibilities under the Act. So this tool applies to a very specific kind of concern. It is about disclosing or blowing the whistle on serious wrongdoing. And that serious wrongdoing is in the broader public interest to report and investigate. So before we go into what wrongdoing means, I'd like to provide you a brief overview of the law. And if you'd like more information again after this, we encourage you to take our e-learning course and to check out our website for other resources that we have available. So the Public Interest Disclosure Act provides protections for employees and former employees in BC to speak up about serious concerns in their workplace. The Public Interest Disclosure Act PIDA is BC's whistleblower protection legislation. So what is whistleblowing? Well, basically an employee or a former employee raising concerns of serious wrongdoing from within their organization. I'm going to get into the definition of wrongdoing under PIDA in a few slides. What does PIDA do? The Act carves out an exemption to the general common law duty of loyalty that employees owe their employer by creating pathways for employees to safely disclose confidential information to facilitate reporting wrongdoing. So employees in the context of PIDA can include permanent, part-time, temporary, or auxiliary employees, and it also includes co-op students. What it doesn't include is certain roles in an organization, such as contractors or volunteers. The Act also provides protection from reprisal or retaliation for employees who speak up about wrongdoing, and it includes confidentiality protections. Only employees and former employees in sectors and organizations covered under PIDA can report serious wrongdoing about a public body and have the protections that PIDA provides. The leaders in your organization will know when PIDA applies to you and your organization specifically. And if you're unsure, check in with them. But we also have a list on our website of who is currently covered under PIDA in British Columbia and how it is rolling out in the province. PIDA plays an important role in preserving the integrity of the public service, and you have a role as a supervisor in ensuring this integrity. You're also an employee under the Act, so you have protections as well. And so we're going to be covering that as well today. So under PIDA, we're focusing on serious wrongdoing that is in the public interest and not just personal interest to investigate and address. The outcome of an investigation under PIDA is to make change more broadly, whereas a concern that is perhaps more in line with an HR concern or a grievance is about looking for an outcome for that specific employee on a personal level. So of course, the issue that an employee raises could be brought forward using a few tools. So it's important to know about PIDA as one of the tools so you can inform them of their choices. So let's review the 5 types of wrongdoing defined under PIDA. The first is a serious act or failure to act that, if proven, would constitute an offense under an enactment of British Columbia or Canada. So essentially, this means something serious that is also illegal. So is something serious happening at the workplace that would be deemed an offense? The second is an act or failure to act that creates substantial and specific danger to the life, health, or safety of persons or to the environment, other than a danger that is inherent in the performance of an employee's duties or functions. So just to clarify this a little bit, a substantial danger means a serious danger likely to result in real harm. So this includes extreme damage or threat to the environment. And a specific danger means there's an actual threat and something or someone is at a particular risk. The danger has to be identifiable and expected at a foreseeable future date. And it's important to note here that that danger that is a typical part of someone's job is generally not included. Third, a serious misuse of public funds or public assets. So in other words, use of public money or assets that is not authorized or approved, or that is illegal, or that is not in line with the relevant legislation, regulations, policies, and procedures. Fourth is gross or systemic mismanagement. So this is mismanagement being the inappropriate or irresponsible management of a government resource, such as staff, a contract, or a project. And gross has similar meaning to serious. And lastly, directing or counseling a person to commit any of the above. So that's a lot to know. There are a lot of considerations when it comes to whether a disclosure of wrongdoing meets the threshold of serious wrongdoing according to these definitions in order to be investigated under PIDA. But don't worry, it's not your job as a supervisor to determine what is and what is not wrongdoing. You don't have to assess, nor should you guess. Instead, your responsibility is to hand over any disclosures directly to your designated officer. And we'll be revisiting this responsibility in a few slides. But it's important for you to generally understand what types of concerns are investigated under PIDA to help you identify when PIDA could be an option for employees who come to you. And that way you know when to ensure that you have presented PIDA as a tool or an option for them when they bring up their concerns or ask you for advice. So we thought it'd be helpful to go through a few examples of wrongdoing that might be investigated under PIDA. And I say might because so much of each disclosure is contextual, and there are many considerations when investigators are determining whether the concern amounts to wrongdoing under PIDA. So while we can't guarantee that if these problems arise in your organizations, that they would be investigated as wrongdoing, they might help you gain a better understanding generally of wrongdoing as defined by PIDA. So here's a few examples. Organized fraud conducted by one or more people. Ongoing practices of burying important reports might be considered wrongdoing under PIDA. Systematically blocking patients or inmates or clients from accessing complaints mechanisms. So putting up barriers to service users accessing complaint processes might be considered wrongdoing under PIDA. Negligence causing death or serious harm, or an ongoing culture of sexism or other kind of discrimination that's not being addressed by management. So again, these examples are just for the purpose of helping to illustrate what kinds of concerns might be considered wrongdoing under PIDA. All disclosures of wrongdoing are fully assessed based on their particular context and the information available. And so your job is generally to understand when PIDA might be a useful tool to respond to someone's concerns. And a good rule to ask is it in the public interest to investigate this issue? Will an outcome of an investigation potentially benefit the public? And if the issue and the outcome are aligned with the broader public interest, then PIDA might be a good option for that employee's concerns. So before we move on, let's just discuss what we actually mean when we say disclosure under PIDA. So the purpose of a disclosure is for employees or former employees under the jurisdiction of PIDA to report wrongdoing. If they're going through, if someone's going through that process of reporting wrongdoing, they are making a disclosure. So PIDA provides a process for reporting that wrongdoing. The form of the disclosure must be in writing. So this might be in the form of an email or a letter, or your organization might have a standard disclosure form for people to fill out. If someone needs help putting their disclosure in writing, assistance should be provided by your organization. And the content of the disclosure must include the description of the wrongdoing, the name of the person alleged to have committed the wrongdoing or about to commit the wrongdoing if that's known, the date of the wrongdoing if known, and whether there's another mechanism or avenue that the employee or former employee is obliged to report under. And if so, what that mechanism is, and has it already been reported through that avenue, if that's known. So once all of these are met, the employee knows they are reporting under PIDA, they provide that disclosure in writing with all of the content that needs to be included, and it's submitted to the correct person, then they have made a disclosure under the Act. And employees and former employees have a choice as to who to submit this disclosure to. So we're going to go through who can receive a disclosure now. So an employee or former employee has choices in how to report wrongdoing. They can disclose wrongdoing internally to their supervisor or to their designated officer in their organization. So your workplace will have its own procedures on how someone can disclose under PIDA. So it's important for you as a supervisor to find out who your designated officer is and what the procedures are for you to pass on disclosures. And employees can also report wrongdoing to the Office of the Ombudsperson. It's important to note that employees don't have to exhaust any internal complaint mechanisms before reporting wrongdoing to the Ombudsperson, and there aren't any time limits for doing so. And under some very limited circumstances, PIDA also allows for reports of wrongdoing to the media. In circumstances that pose an imminent risk of serious danger to the health and safety of people or the environment, employees can make a public report of wrongdoing only if prior approval has been received from the Provincial Health Officer, Emergency Management BC, or the police. So there are many protocols to follow. So getting advice or visiting the Ombudsperson's website for information is important if an employee is considering that particular pathway. So that was a brief overview of PIDA. I know that was quick. There's lots more information available to you on our website for you both as an employee and as a supervisor about PIDA. And we'll cover some of those resources closer to the end of the webinar, but we're now going to dive into your specific responsibilities as a supervisor. So I'll hand it over to Lindsay now to take us through those.
Great, thank you. So now let's talk about your specific responsibilities under the Public Interest Disclosure Act. As a supervisor, you have three main responsibilities under PIDA, and this is the same for all supervisors, regardless of your own organization's procedures. So employees seeking advice on the Public Interest Disclosure Act can seek that advice from you, their supervisor, and we'll talk more about this in a moment. Employees can disclose wrongdoing directly to you as their supervisor. And lastly, in terms of your three responsibilities, there are confidentiality expectations included in each of the above two responsibilities. You have the responsibility to keep an employee's identity and information confidential to the extent possible. Now, don't worry, we're going to go through each of these responsibilities in more detail. Um, but I do want to let you know that you can check out the PIDA legislation itself. You can actually find a link to it on the Ombudsperson's webpage or by simply looking up Public Interest Disclosure Act BC. It might be handy to bookmark that and take a read to find where supervisor is mentioned to read your responsibilities connected within that legislation. And specifically, your responsibilities are actually listed in Part 3 of the Act, which is entitled Making Disclosures. So you may want to refer specifically to that section. Before we move into your specific responsibilities as a supervisor, we're going to pose a situation related to PIDA. We're going to pose it first, and then we're going to revisit this scenario later in the webinar to answer the question. But for now, you can think about the situation as one that you might be faced with at some point. Here we are. A staff member tells you that they think a supervisor in the organization inappropriately claimed per diems for a number of recent work trips, and also had concerns about their misuse of a company vehicle for personal reasons. They don't know if they should make a disclosure under PIDA. They ask you for your opinion. What do you tell them? So take a moment and reflect on this situation, and then we're going to revisit it in a few slides and answer this question once we go over your specific responsibilities as a supervisor under PIDA. So your first responsibility, responding to employees seeking advice. So first of all, it's important to determine whether the request for advice is related to the Public Interest Disclosure Act, or PIDA. An employee who comes to you for advice about something they know about or witness that they feel is wrong may not actually use the term whistleblowing or PIDA. They might come to you generally requesting advice about a concern, and they might not know about PIDA. Clarify that they're actually requesting advice under PIDA as opposed to a program area or an HR inquiry. But stay as neutral as possible during this by letting them know about PIDA as an avenue available to them and letting them choose whether it's a relevant option for them or not. So next, once that has been clarified, you can let them know about PIDA procedures and protections. This is where it's important for everyone, including supervisors, to know about PIDA. Some options to stay informed is our PIDA course for employees, our website, and your own organization's information on their internal process. Your organization should also have information available to their employees, so get to know that information and where it is so you can pass it on to staff who may be seeking advice. And make sure you let them know that a disclosure must be in writing and that they have a choice as to where they can go to disclose. Also, they don't need to have gone through all the other options for speaking up on that matter before they disclose under PIDA. Next, it's important to note that you do not give your opinion about whether or not an employee's allegations are eligible for an investigation under PIDA. But you can provide the employee with information about how wrongdoing is defined under the Act. The designated officer or ombudsperson staff, depending on where that employee makes the disclosure, will make this analysis of whether the disclosure actually meets the test of wrongdoing. But assure the employee that their concerns will be taken seriously, but do not promise that they will be investigated. Wrongdoing reports are assessed against PIDA's criteria to determine whether they will be investigated. If an employee is not sure if what they witnessed is wrongdoing, encourage them to disclose anyway. It's better to err on the side of caution, and they will still be protected from reprisal. We like to use the phrase when in doubt, report. Next, document the request and the advice given and keep those records safely stored and confidential. You can also ask that requests for advice be in writing. As well as approaching you, their supervisor, employees can seek advice about making a disclosure under PIDA from their union or employee association representative, a privately retained lawyer, their designated officer within the organization, or the ombudsperson. And lastly, an employee can ask for advice on disclosing wrongdoing, but they might also ask for advice about making a reprisal complaint. We're going to get to that information in a few slides. So we're going to go through a couple what ifs, a couple scenarios. So the first one, what if you don't know how to answer a question in the moment? Don't worry if someone is asking questions about PIDA and you don't know that information right away. Know that we have resources that you can refer to. Your organization should have resources, And you can let the employee know that you will get back to them. You can also let the employee know where they can find the information themselves. What if an employee asks you whether there's a time limit for disclosing? Well, you can let them know that no, there actually isn't a time limit. PIDA does not have any time limits when it comes to disclosing. However, it may be a decision, that a decision might be made not to investigate wrongdoing that perhaps happened a long time ago. And lastly, what if an employee who you do not supervise or doesn't officially report to you comes to you for advice or to report a disclosure? Well, you still have responsibilities to maintain confidentiality and ensure the person knows about the protections under PIDA and has information about how to submit their disclosure. If you don't supervise the person in any capacity through the official reporting structure in your organization, you should make sure that they know they can be seeking that advice or submitting their disclosure to the person that is actually their supervisor, or from other persons listed in PIDA who can provide advice or receive disclosures. So let's go into your second responsibility. Now, what do you do when someone discloses? Well, first of all, make sure it's in writing. This is required under PIDA. Your own workplace or organization will likely have a form that will be used for this purpose. But if there isn't a form, it can be done in the form of a written letter or an email. So let the employee know if there is a form and how they can access it. And if not, let them know that they can do that through an email or in the form of a letter. And once the employee records their disclosure, it can be submitted back to you, their supervisor, or directly to your organization's designated officer. Next, after receiving the written disclosure from an employee, you immediately provide it to the designated officer in your workplace. And if you find that the report is incomplete, provide it to the designated officer anyways. The designated officer can then contact the employee for more information. PIDA allows for anonymous reports. So even if you're unsure whether an anonymous report is from an employee, still provide it to the designated officer. And it's just important to note that you submit the report to the designated officer regardless of whether you think it qualifies as wrongdoing. Remember that it's actually not up to you to make that assessment. That is the designated officer's responsibility, and they may wish to consult with our office in making that determination. So let's go through some more what ifs when it comes to receiving a disclosure. So what if the employee has a barrier to writing down a disclosure? So if an employee needs assistance in putting the disclosure in writing, either within a form or in a document, you can help them. Having the requirement to be in written form is not meant to be a barrier, so provide assistance if needed. What if the employee just doesn't want to write down the disclosure? Well, PIDA says the disclosure must be in writing and contain certain elements. If an employee simply refuses to put their disclosure in writing for no reason, then it would not be considered a disclosure. Putting it in writing is a way to ensure that the person wants to make a disclosure and provides clarity about their concerns. And then lastly, what if you don't know how to get the disclosure to the designated officer within your organization? We'll check with your organization about how to forward the disclosure to the DO or the designated officer. There might be a specific process, so find that out beforehand so you're ready to do so if someone discloses wrongdoing to you. And always ensure confidentiality when doing so. And if there isn't a specific process laid out, just be sure that however you are getting that disclosure to the designated officer, that you're doing so discreetly. Your third major responsibility under PIDA is to maintain confidentiality. This is a protection that PIDA provides for disclosures. PIDA contains protections for the identity of employees who report wrongdoing or seek advice about reporting wrongdoing. So because you have a responsibility under PIDA to potentially provide advice and receive disclosures, you have a responsibility to keep the identity of employees confidential. So in addition to the confidentiality requirements, confidentiality is important because it protects employees from reprisal. It keeps the focus on the issue, not the disclosure. We never reveal the identity of the disclosure in an investigation, and instead we focus on the issue of concern. And it encourages employees to speak up about wrongdoing by creating a safe environment where their identity is protected. This confidentiality requirement means that when it comes to some of your usual practices of reporting your work to your manager or leadership, that does not apply when it comes to PIDA. PIDA matters are brought to you, PIDA matters that are brought to you must remain confidential. So no reporting on them to your manager or discussion of them with your colleagues. So let's go through some important points related to confidentiality. So as best as you can, if someone comes to you for advice or to disclose, you keep the employee's identity and information confidential. This includes keeping written documentation private and secure. Don't share any information gained from a request for advice. This includes the designated officer. So for example, if someone comes to you for advice and you can't answer their question and you need some help, you can absolutely go to your designated officer, but you cannot tell your designated officer who has asked for advice. The only time you share information is when you pass on a disclosure that you received onto your organization's designated officer. This is the only person you share this with. Since they are the ones receiving the disclosure and ultimately investigating, they have that information, but no one else should. And there are a couple of exceptions when it comes to the confidentiality protections. You can share information if there is a legal reason to do so. For example, if there is potential for danger or harm, then information can be shared in order to keep people safe. Or if the employee gives written consent that their identity can be disclosed beyond the rules stated above. So let's go through some more what ifs related to confidentiality. So what if an employee tells you something that you would normally deal with as part of your regular responsibilities? Are you prevented from doing so because of PIDA? Well, PIDA isn't meant to restrict your responsibilities under other processes. You're allowed to and still should deal with those issues that you otherwise take on due to your regular supervisory responsibilities. And remember, Rachel mentioned all of the other tools that you have, for example, standards of conduct or HR processes. PIDA is not meant to restrict or replace those other processes that may apply to a specific situation that is brought to your attention. PIDA shouldn't be an impediment to carrying out your other duties. If you have other ways of dealing with wrongful conduct, such as through your organization's standards of conduct, you should do so. If you have questions, talk to your designated officer, but remember to discuss the issue without identifying the disclosure in any way. What if wrongdoing is happening right now and is putting people in danger? Are you still expected to keep everything confidential? If wrongdoing is happening right now and is endangering others in the organization or the public, you are expected to take steps to stop it from happening. You have legal reasons to do so, such as to ensure worker health and safety, or to deal with a potentially dangerous, current or ongoing problem. You do have an obligation to keep your staff safe, and PIDA is not meant to impede your ability to do so. So let's revisit that initial scenario. And now that we've reviewed your responsibilities and some information about PIDA, let's answer that question. What do you think you should tell that staff member? Well, if you are that employee's supervisor, you can provide them advice under PIDA. If you are not their supervisor, suggest they seek advice from someone authorized under the Act. So for example, their direct supervisor, the designated officer within the office, the ombudsperson's office, their union rep, or a privately retained lawyer. But assuming that you are their supervisor, don't assess their disclosure. You can provide general information about what constitutes wrongdoing and refer them to our website for more information. Explain that they are protected from reprisal for seeking advice and for making a report if they do so. But encourage them to make the report if they want. The process is confidential. It will be assessed by either the designated officer in the organization or the ombudsperson, depending on where they report. And if it's determined not to rise to the level of wrongdoing, they will be notified. So I'm now going to pass things back to Rachel to finish up with some information about reprisal under PIDA and to go through some final tips before we conclude the webinar.
Great, thanks, Lindsay. So we've gone through the three main supervisor responsibilities under PIDA, being there for employees who are seeking advice, being available to receive disclosures of wrongdoing, and then maintaining confidentiality to the extent possible. There's another key protection that PIDA provides employees and former employees who seek advice, disclose, or cooperate with an investigation. And that is the protection from reprisal, or in other words, retaliation. So it's a provincial offense to commit reprisal against an employee who reported wrongdoing or sought advice about reporting wrongdoing, or against someone who cooperated with a PIDA investigation. And as a supervisor, it's important to know about this protection and what to do with reports of reprisal. So reprisal can come in many forms. It can be discipline, demotion, a termination. It can be bullying in the workplace or exclusion, basically anything that is adversely affecting someone's employment or work conditions. Also, reprisal isn't just about what a manager or supervisor might do, but reprisal can also come from an employee's coworkers or peers. This can be a one-time incident, or it can be a series of events. But whatever it is, whatever is happening, it has to be as a result of a protected act under PIDA. So it has to be tied to that protected act. So that, again, is asking for advice under PIDA, disclosing wrongdoing, or cooperating with a PIDA investigation. It has to be tied to one of those protected acts. And as for the process of reporting reprisal, only the ombudsperson takes reports of reprisal. So remember, there's a choice model for making the actual disclosure of wrongdoing. Well, with reprisal reports, there is no choice. Only the ombudsperson can take these reports and investigate. So we assess reprisal complaints in the same way we would reports of wrongdoing. And if they're investigated, they follow the same process. So if an employee or a former employee has questions about our process, you can just let them know they can contact our office directly. And lastly, reprisal protections apply even if the disclosure's allegations aren't substantiated. So those protections still apply under PIDA. So let's add a few final tips to your tool belt as supervisors as we close off here. First, hold your conversations with employees and former employees about PIDA privately to maintain confidentiality. And while giving advice or receiving a disclosure, be sure not to make any promises about what will happen next or about whether or not it'll be investigated. Always keep documentation of your PIDA interactions and let the employee know that they should document the interactions as well. Or alternately, you can provide that employee with a copy of your documentation for their own records. Store your files related to PIDA in a secure place. So for electronic records, this means a secure password-protected drive that is only accessible to you. Paper files should be securely stored in a locked location. Try to stay neutral. Remember, your job is to provide information on an employee's choices and encourage them to report wrongdoing if they want. It's not your job to assess their allegation. Remember, that's up to the designated officer or to the BC Ombudsperson's office. And when in doubt, reach out. Always feel free to reach out to us for help or to your organization's designated officer if you need it. So let's just revisit your responsibilities as a supervisor. You have a responsibility to respond to requests for advice from employees about PIDA, to receive disclosures of wrongdoing from employees, which you'll then pass along to your designated officer, and to maintain confidentiality to the extent possible throughout the process of responding to requests for advice or disclosures. And remember, PIDA applies to you too. So you also have the same rights and protections as any employee of an organization that's covered under PIDA's jurisdiction. So I'll finish off by saying PIDA is really about supporting a speak up culture, and you as a supervisor are part of that culture. So you have an important role within it. And a speak up culture is a healthy, supportive environment where people feel comfortable and supported in sharing their ideas and concerns. This is a culture where people don't fear retaliation for speaking up about things they experience or that they witness that they don't think are right. There are lots of ways and reasons that people might feel compelled to speak up. PIDA is an option for employees, including you, within the public sector to speak up about serious wrongdoing that you hear about. And it's a tool to encourage that broader speak up culture. And that's really about creating positive change that's in the public interest. And it takes courage for anyone to step up and speak up. It means going against the grain a little bit and possibly doing something that's uncomfortable. And lastly, a supportive environment is required. So employees need to feel like they have someone they can ask advice from and get information from and to disclose to. So you as a supervisor are an important part of that speak up culture, and you benefit from it too as an employee yourself. So we've covered a lot in this webinar. You probably feel like you might need some more resources, maybe some more information. We really recommend that everyone, supervisors included, should take our employee course, our PIDA employee course called Speaking Up Safely. It provides an overview of PIDA, and it's available on our website for anybody to access. There are also additional resources for supervisors on our website. So we have an FAQ page and a number of other resources that will hopefully answer any last questions that you might have. And the Office of the Ombudsperson will be providing organizations with opportunities for consultation as they implement PIDA, as it rolls out from April 2022 forward. So you can find all of these resources on our website, and we can certainly be available for any further questions that you have. And there's the link to our online learning. So here's our contact information for you to reach out to us. If you're looking for specific advice about a disclosure or how PIDA fits into your existing policy framework, you can contact the Public Interest Disclosure team at report@bcombudsperson.ca. If you're looking for training or additional educational resources, you can email our team, the Public Authority Consultation and Training team, at consult@bcombudsperson.ca, or call us anytime on the number on the screen. So thank you for joining us today. We hope the information has been helpful, and we look forward to working with you in the future. Thank you.